I've done research. I've developed and delivered training for lawyers, for judges, for frontline workers. I've written resources for women and for those who provide support services to them. And perhaps most significant of all, I've been an advocate for system change. Most often my work is collaborative because I believe wholeheartedly that we are our best selves when we work together, even when that means we're working across differences. Throughout these 2 decades plus, my work has remained rooted in the experiences of survivors of gender-based violence and of the frontline workers who support them. Overwhelmingly, what I've learned is that by and large, the legal systems that should offer safety to women and children fleeing abuse fail to do so day in and day out. I'm going to talk mostly about family law, but it's important for all of us to bear in mind that other legal systems, criminal, child protection, immigration, intersect with and have an impact on what happens for women in their family law cases. So we can't silo women's legal experiences and say, we're just going to look at the family law piece here, because if her partner's been charged or if she's been charged, what's going on in criminal court is going to have a profound impact on what happens in family court. If a woman has separated from a partner who has abused her and child protection services are involved, that's her highest priority. Most parents are terrified of child protection. And so to try to sit down as a family law lawyer and talk with her about, property division, getting a share of hubby's pension, when she's worried about that next visit from the CAS social worker, she's not hearing anything you're saying. So we need to see how these systems not necessarily work well together, but intersect and overlap with one another. As I said, I'm going to start by walking through some of the challenges that women leaving relationships in which their partner has abused them face. But I'm also going to talk about some of the positive things that have happened, in particular recent changes to the Divorce Act. When a woman with children leaves a relationship in which her partner has abused her, usually her first concern is about arrangements for the divorce. I remember, and it still happens when I talk to women, I don't have a practice now, but I work in an organization that provides legal services. And often in the first appointment, lawyers will tend to think, well, let's just run through everything here. We need to talk about custody and access. We need to talk about division of property, child support, spousal support. You lost her after custody and access. That's all she really wants to talk about in that first visit, because that's what she's the most concerned about. Of course, changes to the Divorce Act mean that we're not supposed to use the words custody and access anymore. We talk about parenting time and decision-making responsibility, so we can come back to that a bit later. Women who've left abusive partners need and deserve a legal system that is able to adequately assess and address the violence to which they've been subjected in its decision-making about parenting. It's not appropriate in 2022. It wasn't appropriate long before 2022 for a judge to say, for example, Ms. So-and-so, I accept your evidence. I accept your testimony that your partner was abusive to you, but that's irrelevant to the determination about arrangements for the children. I don't know whether judges in Yukon would ever say such a thing, but we hear it in Ontario a lot more than we should. There's still this kind of bifurcation that what happens to mom has nothing to do with the children. Now, we could spend the whole evening talking about the impact on kids of being exposed to abuse, but then you wouldn't be listening to me because I'm not a social worker, I'm a lawyer. It's pretty obvious to me that when children are growing up in a home where one of their parents is being abused by the other, whether they're in the room when it happens or not, it's affecting them. At least equally important from my perspective as a family law lawyer is this. If he's abusing their mother, that has to be a consideration when deciding on appropriate parenting, because someone who's willing to abuse the other parent of the children surely lacks some of what we're looking for in a good parent. So we still, unfortunately, see too many cases where the courts are not understanding that. And sometimes what it does is leave the mother exposed to horrendous ongoing abuse because she's in a situation where she has to consult with the father about all of the decisions, or there's such extensive access and so frequent exchanges that, you know, every one of those points is an opportunity for further abuse. But in some of those situations, the children are harmed. I feel like I can tell some bad stories. You sort of got warned. There would be some tonight. I think a lot about a case in Ontario that may have made the news up here. A woman named Jennifer Kagan, a fairly wealthy woman, a doctor, left an abusive relationship very soon after her daughter was born, mostly coercive control, and fought very hard in family court. And she was one of those women, and they're a minority, who had the financial resources to do it, who had the personal ability to do it. And in her case, the judge said just what I said a few minutes ago. I believe you, Ms. Kagan, Dr. Kagan, that your husband was abusive to you, but it's not relevant to my considerations about arrangements for your daughter. So Kira had extensive time with her dad, whose behavior became increasingly concerning. Jennifer went back to court and went back to court and went back to court. And Jennifer's father killed her. Even though a judge had 3 days before the murder identified that he thought the father was at high risk, but he should have his time with their daughter. So it's both the mother and the children who are harmed when courts don't look closely enough at the impact of violence between adults on the children. At Luke's Place, which is where I'm the legal director, it's a community-based organization in Durham Region, Ontario, we see women frequently who have left relationships that have been defined by ongoing and severe, controlling, fear-provoking abuse. And we see those women leave family court with orders for equal shared parenting time and shared decision-making responsibility. The time the children spend with their father, even when the mother has serious concerns about their safety, is often unsupervised. The environment for those kinds of arrangements, shared parenting, shared decision-making, just don't work well in those families. They work well in lots of families. My daughter, now her kids are fully grown now, but when my daughter and her partner split up, they co-parented their children for 15 years. That wasn't always easy, but they did it, and they did a good job of it because there was no abuse, because neither of them was afraid of the other, and because they were able to put the interests of their children first, which lots of people can't do, especially in that immediate aftermath of a separation, where one person feels betrayed or hurt or whatever by the other. So I'm not here to say, oh, shared parenting is a terrible thing. I think it's a wonderful thing. But the law has to speak to the most vulnerable. And the most vulnerable are the people who cannot make that work in a way that is safe. Safe for the adults and safe for the children. Too often when we talk about violence against women, especially if we're talking about it, let's say in a policy context, those conversations, those discussions, those decisions are based on what people call a gender neutral analysis. But that's not really gender neutral. So what do I mean by that? The fact of the matter is that the majority of victims of the most serious kinds of abuse are women. Coercive control, which we're only now starting to understand as a term, describes that sort of panoply of abusive behaviors that are not necessarily physical. Gaslighting, controlling, shaming, isolating, controlling financially, over 90% of the victims of coercive control in heterosexual relationships are women, which means because they're heterosexual relationships, most of the abusers are men. The vast majority of victims of domestic homicide are women, and most of the time they're killed by an opposite sex partner. Absolutely. Men can be victims of abuse by their female partners. There can be abuse in same-sex relationships. We now have a much broader and more inclusive understanding of gender. There can be abuse in any relationship. But when we look at the numbers, when we look at who's coming in through the hospital emerge, who's dead, and who's a victim of coercive control, it is significantly more likely to be women. So if we keep saying, well, we have to use a gender neutral approach, we have to just call everybody he, we have to assume it could be either person, we're not dealing with the reality of what's going on in families. So when we do that, we reflect and reinforce the status quo. And we maintain the ongoing inequality of women, with the result that outcomes are often unsuccessful, inadequate, or counterproductive. Even at times, those outcomes may make the situation worse. A lot of this public discourse, policy work, also originates in what many would call a culturally neutral place, which does not acknowledge the complex intersectional realities faced by many families. I'm not just, let's say, a woman who's been abused by my partner. I may also be an Indigenous woman. I may be a woman with disabilities. I may be a queer woman. I may be a very young woman. I may be an older woman. I may be a newcomer, right? The list is a long list. And as soon as I start giving any examples, I worry about which ones I left out. So our legal system has to understand that as well. This is particularly apparent when we look at violence against women within the family, often called domestic violence, family violence, intimate partner violence. Do you hear the word gender or woman anywhere in any of those terms? No, you don't. As I said, violence within the family is in fact highly gendered. It is significantly affected by the social location of women and others in the family. So here's another example. I was surprised to learn this many years ago now. I got my feet wet doing this work before I was a lawyer because I was a volunteer at the women's shelter in my community. Not surprisingly, most of the women who came into that shelter were poor. And so I thought, oh, this is a bigger problem for poor women than for women who have money. But that's wrong. Those women are the more visible women because they don't have the personal resources to help them get out of the relationship. If I, the person I am, had to leave an abusive relationship now, heck, I've got enough money and I could get a line of credit to rent an apartment, maybe even to buy a house. Because poverty and wealth are often similar across families, I have sisters who are comfortably off and have space in their house where I can go to live. The police are less likely to be called out to my home if my partner's abusive to me because I live in a single family dwelling and there's no neighbor through a thin wall who hears what's going on and calls the cops whether I want them called or not. Right? So we have to look at the fact that this is something that permeates whoever we are. Jennifer Kagan is a great example of that. An affluent family physician in the biggest city in the country. And yet the family law system did not keep her child safe. To make effective and appropriate parenting decisions in families where violence is present, courts have to abandon that so-called gender-neutral framework and replace it with a framework that identifies the problem correctly. We can't group all what I call unhappy or bad relationships together as though they're the same. So, Leslie, you're going to be my spouse here for a minute. You know, maybe we have a terrible marriage. We bicker, we quarrel. But neither of us is afraid of the other. Okay, we shouldn't be doing that. That's not fair to either one of us. And if we have kids, it's really not fair to them. But that's a far cry from a situation where I'm abusing you to the extent that you're terrified of me. You feel you have no autonomy, that you can't make your own choices. But the law kind of tends to clump all of that together as abusive or domestic violence or so-called domestic violence. Now, I'm going to talk about the Divorce Act in a few minutes, and I think we're starting to make some significant headway. But for a long time, they've all just been lumped as one kind of high conflict separation, a term that I'd like to see eliminated entirely. So when we do that, the problems incorrectly identified, the gendered reality of family violence is missed, and a one-size-fits-all approach that focuses on maximum contact between children and both parents, regardless of the history of abuse, is what happens. And that leaves these particular women and children exposed to ongoing danger. Let me be clear, I'm not in any way saying that where there has been abuse, the abusive parent should not ever see the children. I'm not saying that at all. What I'm saying is that arrangements that maximize the contact, especially if it requires the mother to be the mediator, the intervener, the transporter, the exchanger, those are not appropriate situations. And if my partner cannot treat me with respect, shared decision-making is not going to work. If I'm afraid of my partner and our 10-year-old daughter has been playing soccer for the last 4 summers, and my partner says, well, this year it's going to be baseball, I'm going to agree because I'm too afraid to say, well, why would you do that? She loves soccer, right? So decisions get made that aren't focused on what's best for the kids. It's my opinion that the family court system is largely premised on a friendly parenting concept that does not understand the prevalence of post-separation abuse. And that creates serious challenges for women who deal with ongoing abuse. Again, this is something I didn't know when I started doing this work. I was volunteering at the shelter, and a woman came in late one evening, and I was sitting with the intake worker, and it was obvious the woman had been in the shelter before. So she went through intake, went off to her room. And I looked at the worker and I said, you would let a woman come here twice? I just sort of thought, when you get out of an abusive relationship, it's over, and you would never be back in it. I mean, nobody in this room thinks that, but I did until I knew better. And there are still people who women encounter in their journey through family law who have a bit of that kind of an attitude that it's, you left, it's over, time to look forward, stop looking over your shoulder, put the past behind you. So that's what I think of as the unwritten shared parenting presumption that exists in Canada. There's lots of reasons for that, lack of awareness, lack of knowledge. Also, because we have this very high rate of unrepresented litigants, those people aren't necessarily putting needed evidence before the court. They don't know what the court needs to know. I mean, any of you, I think a lot of you are lawyers. I'm sure many of you have sat with clients, women in particular, who say, well, why would I have to prove I'm a good parent? I always took care of the kids. Well, you do, in fact, have to prove that you're a good parent when you go to family court, if the other parent is going to put up a fight. But if you don't know that, and you don't have a lawyer who says, well, yes, you do, you're going to waltz into court without the evidence the judge needs to hear to make the best possible decision for your family. I mentioned post-separation abuse just a couple of seconds ago, and I feel the need to make a couple more comments about it because it is so prevalent. Research across Canada has well documented that women are at the highest risk of being killed from the time their partner perceives that the woman is about to leave the relationship through the point of separation, and most seriously for the year immediately following. Well, that's just when these families are involved with family court. Tensions rise. Like, going to family court is not fun for anybody. But that often goes unrecognized or acknowledged by the systems to which women turn for support and protection. We can't not talk a little bit about trauma. The combination of past and ongoing abuse leads to trauma for many women, which can create further challenges for them during their family court proceedings. Whether a woman has difficulty concentrating on her case, listening to and retaining information, accepting strategies that are presented to her, being agreeable, because there's nothing worse than a disagreeable woman. Getting to appointments or completing paperwork on time, she will be viewed in a negative light. Particularly if her abuser, as is common, is charming and gracious to everyone he encounters, even as he's privately bullying her throughout that process. So let me go back to Susanna for a minute. My first client, right? We had a settlement conference maybe 3 months after she first came to see me. So for those of you who aren't lawyers, that's when the parties and their lawyers sit down with the judge in a somewhat informal setting to see if they can work any of the issues out before litigation goes farther. And at the time in Kingston, the judge would come out of chambers, would not be robed, and we would sit in the library of the courthouse. So I'm sitting on one side of the table with Susanna, her ex, and his lawyer are on the other side of the table. The judge is at the head of the table, and there's a security person in the corner. And it was our motion, so like we were the applicant. And I began by summarizing the concerns that my client had and why she wanted to have what was then called sole custody. Well, this story is funny to me because it had a good ending, so I start laughing too early and then I horrify everyone. Her husband jumped up on the table and grabbed for her throat. Not funny, but goes well. The judge was out of that room so fast, he barely saw her turn around. And as she was running out the door, she yells at the lawyer for the father, "Get your client out of here, get him under control, and make sure he understands that he's probably not going to win today." Right? So things settle down. We're successful with our motion. Remember, this is my first client. I now think, great. All I have to do is provoke the guy by listing the things he did. He'll jump up on the table and we'll get what we want. Never happen again. Never. Because it's true, in my experience anyway, and when I let you folks start talking, you can tell me about your experiences, that a lot of abusers are very good at playing the system. And they know how to charm the judge. Ron, perhaps you've been charmed a time or two, I don't know. Abusers love going in front of the judges because they like to be flirtatious with them and butter would melt in their mouths. Because they're not scared of their partner who's sitting in the courtroom frightened, maybe a bit disorganized because of the trauma, because they don't have a lawyer, because the babysitter didn't show up, because they're missing time at their hourly paid job, right? So he comes across looking quite reasonable, looking and acting more like the judge. And let's be honest, we're all more comfortable around people who are a lot like we are, because we don't have to work so hard to understand them. I had some clients who were horrible women in the sense that they were unpleasant, they were argumentative, they canceled meetings, they didn't show up for meetings, they came late, they argued with me about everything, they didn't pay their bill. But that didn't mean that they couldn't also be victims of intimate partner violence. Like, you have to separate those two things out. You can be a really crabby person. It doesn't mean your partner gets to be abusive to you. So that trauma piece is big. And until lawyers and courts can bring a trauma-informed approach, and we're making some progress, women will continue to be seriously disadvantaged. Family court itself, I think, is part of the problem because it encourages friendly litigation as well as friendly parenting. Friendly litigation, kind of a contradiction in terms. I'm all for mediation. I'm all for working things out. But if we're at the point that nobody can talk together well enough to mediate or to collaborate, and we're litigating, we're not friendly. by definition. And if there's abuse, more than we're not friendly, there's danger in the air. There are serious safety issues that need to be recognized. Many women have reported to us at Luke's Place that subtle and not so subtle hints are dropped by those they encounter throughout the family court process that they should set their own concerns for safety aside in order to put their children first, which is a profound insult for any parent. Women with abusive partners tend to be intensely focused on their children's well-being, often to the detriment of their own. They're sometimes told, even by their own lawyer, that judges like parents who are prepared to work together. The organization I work for, Luke's Place, is named after Luke, who, when he was 3, his mother left with him, left his father because of abuse. Her brother picked her up, drove her to the shelter with her husband chasing in the truck. He pulled into the parking lot of the shelter behind them. They had to get police to escort her into the shelter. She went to court a few days later. She wanted sole custody. And he conceded to that pretty quickly, the father. But she also wanted the access to be supervised on a temporary basis because she thought he was particularly unstable at this point. And her own lawyer said to her, "You got what you wanted on the sole custody. You got to give up something now." Guess what? Luke never came home from his first visit because he was killed by his father, who then killed himself. So women sometimes get this unfair shake, I guess I'll call it, of being unreasonable or of trying to alienate the child from the father when they're desperately trying to send a message that it's not safe. And of course, I'm telling you the most dramatic stories because that's what you do when you give a talk like this. There are lots of less dramatic stories, but stories where children are still abused by the father, neglected by the father, mistreated, exposed to his abuse of a subsequent partner, where the children become little messengers for dad. Oh, just tell mom how much I miss her, and I just want to come home. Cry, 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 cry. That's a hard thing for a kid to see, especially a young child, a parent crying, right? Or who was that parking in mom's driveway yesterday? What do you think mom's doing with all that child support money? These kids don't even know what he's talking about. But a story starts to build, and either parent can do it. I spend a lot of time with my clients saying things like, you know what? It doesn't matter if you give some crap dinner. I know you're like a natural foods freak and a vegan. This is not your child abuse. This is not child neglect. If they stay up a bit later at dad's, if they come home a bit grubby, that's okay, right? We're not going to court over that stuff. When we go to court, it's going to be because he didn't return them at all, or he told you he was taking them back to his family home in India, which has not signed the Hague Convention, or whatever. So both parents need a lot of coaching, and I'm sure any of you who are family law lawyers will agree that that's what we do. We help our clients not stab themselves in the back, right? So it's difficult. And when you've left a relationship where you've been a victim of severe controlling abuse, and that's ongoing, it can be hard to tell the difference between danger and just something that you're not quite comfortable with. It's really hard to do. I do want to say something about the role of men within the family. The role of men in Canadian families is changing dramatically. And, if we have time, we can do a little go around about how things happen in households that you're part of or that you know about. Certainly when I grew up, I'm 68, my father didn't do anything except bring home the paycheck and tell my mother that dinner wasn't to his liking. And that's not how I raised my children. When I had a partner, it's not how my kids are raising their kids. And so we do need to understand the law in this new context. You remember again, for the lawyers, what's it called? The tender years doctrine, the idea that young children had to be with the mother. I don't think many of us subscribe to that theory or whatever now. But what matters is that the parenting be arranged in a way to minimize ongoing conflict and minimize ongoing safety concerns for the mother as well as for the children. Because one thing that we do know is that if a parent does not feel safe, they're not being the best parent they can be because they're scared. And so that's another way that the family violence can play out after separation, even years after separation for the children. I gather from various meetings that Ron has so kindly set up for me today that perhaps the lack of legal representation that is such a nightmare where I work is somewhat muted here because of the way legal aid provides services. But I'm just going to say 2 sentences about it if I'm allowed to, but it's still a problem here. Okay, great. I'll say 3 sentences about it then. Nobody should go to family court without a lawyer. Would you take out your own appendix? I hope not. Right? Nobody should go to family court without a lawyer, especially a family law lawyer. But if you add to that abuse, it's just shocking to me that politicians seem to think that legal aid is sort of a nicety, and if we can afford it, well, we'll throw a bit of money that way, and if we can't, we won't. Way more money goes to criminal family law. Guess who most of the people are who use criminal family law? Men. Much less money from legal aid flows to family law. Chorus, please. Who's using family law? Women. So we've got a gendered problem in terms of how legal aid is handled, and there's just not enough of it. And everybody can bicker back and forth. Legal Aid Ontario can tell me, oh, Doug Ford cut our budget by a third. Yeah, he did. Sure. And then Doug Ford can say, well, Justin Trudeau didn't give us as much money as he did the year before. Well, that's true. But we've still got to figure out a way how to deal with this. Because, our healthcare system is in a complete disaster now, not just because of COVID, but because of chronic underfunding. But I think it's still not a bad comparison. We do expect, if we have a medical problem, that we will find a trained professional to assist us with that problem. And increasingly, that's not the truth for people who are dealing with family law issues. Okay, way more bad news than you need to hear. Let me talk for just a few minutes about recent changes to the Divorce Act. And again, because I think many, but not all of you are lawyers, let me just explain what the Divorce Act is. It's a federal law. It governs people who are married and who are seeking a divorce. So it applies to people wherever they live in Canada, but you got to be married. And through a divorce application, not only can people get divorced, but they can sort out all those other issues: parenting arrangements, money, property, and so on. You can't get a restraining order, or I think they might be called protection orders here, am I right? Through the Divorce Act. So it's a pretty important law. Provinces and territories have family laws that govern all of those issues for people who are not married or people who are not seeking a divorce. The other thing to know in order to understand the importance of the Divorce Act changes is that all decisions related to the care of children after their parents separate are made using what's called the best interest of the child test. So now the Divorce Act contains a fantastic definition of family violence. It codifies an attitude that many judges were already bringing to these cases, but now it's in the law. So you don't get to say, I don't agree with that, even if you're a judge. And that definition says that family violence is any conduct, whether or not that conduct constitutes a criminal offense. This has been a barrier that women have come up against many times, where the family court judge will say, well, how come you didn't call the police? Or it couldn't have been that serious because he didn't get charged. So now it's right there, whether or not that conduct constitutes a criminal offense. By a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or for that of another person. And in the case of the child, the direct or indirect exposure to such conduct. It's a pretty good definition. It talks about coercive controlling behavior. It talks about fear, and it talks about patterns of behavior. And the best interest of the child test in the Divorce Act now requires the judge to consider, based on this definition, whether family violence was a factor in this family. These are important changes. They're good changes. They've already been reflected in many court decisions. What we now need to do is work to ensure that all of the provincial and territorial family laws use the same language. So I'm happy to say that Ontario, much to my surprise, given our premier, changed its Children's Law Reform Act almost immediately to use exactly the same language as appears in the Divorce Act. Yukon has not done so yet. I think that would be a great thing to have happen. Like I said, it's not as though judges never apply that definition, but if you codify it, it makes it undeniable, really. Along with the changes to the Divorce Act, the federal government has issued a number of really helpful tools for family law lawyers, which many of you are probably familiar with. I think in particular, the Help Toolkit, that's what it's called, HELP, capital letters, it's an acronym for something. And I think I was one of the people who worked on that toolkit. I don't think it's an exaggeration to say we wrote the toolkit more quickly than the government could come up with the name for it. But it is intended to assist family law lawyers screen clients for the presence of family violence. Along with the changes to the Divorce Act, we need more education for lawyers and judges. Why isn't intimate partner violence a mandatory component of a family law course? Any of you who are family law lawyers, could you say that you have had your practice and never seen a case of family violence? We all see it, right? We should know about it when we go in, rather than having to wait and take a continuing professional development program on it 5 years into our practice. Obviously, we also need increased access to legal representation. And I am really proud of a program that Ontario has called the Family Court Support Worker Program that I think every jurisdiction in the country could benefit from. These are workers who are employed by a community agency funded through the provincial government to provide support to survivors of family violence throughout their family law case. They can assist them with safety planning, gathering evidence. They can accompany them to lawyers' meetings. They do the debriefing, the trauma support. They can go to court with them. Whether the person has a lawyer or doesn't have a lawyer, it's free. There's no financial eligibility criteria. Just really quickly, because I do want to have time for you to talk. I want to mention 3 things, and if people are interested, we can come back to them. In other areas of law that I think have an impact or could have an impact on family law, all of which are kind of on the table now, partly as a result of the inquest that Ron mentioned in Ontario, but also because the federal government has indicated it's going to implement something called the National Action Plan on Gender-Based Violence. One is this. Since 1985, all jurisdictions in Canada have had some form of mandatory charging policies, meaning that police in a domestic situation will lay a charge whether or not the victim wants a charge laid. Made sense in 1985. A lot of us think it doesn't make sense in 2022. We've also seen the downside of those policies, where a sloppy police officer charges both of them. The woman only is charged because, Ron, I'm going to make you my spouse now for a minute, but I'll be the abuser. I am coming at Ron, fists out. I am going to grab Ron around the throat. He's backed up against the wall, and he reaches out and scratches my face. So when the police show up, the injury, I'm the primary aggressor here, but the injury to me is visible. The bruises on Ron's neck won't materialize for hours. So mandatory charging had its place. We need to look at it. Is it actually working? How is it being used differentially depending on race, economic status, and other social factors that identify or define the two people. Another second of the three issues that I think are really interesting right now, 3 and maybe 4 provinces have passed protocols called intimate partner violence disclosure. Sometimes they're called Clare's Law. So this is a protocol that says if I'm involved with someone and I've got some, spidey sense or few red flags, I can go in those provinces. I can go to the police and fill out an application. The police will do a check on this individual and share any relevant information back with me. I then can make a decision based on what I've found out. Do I want to remain in this relationship or not? Lots of pros, lots of cons. So again, I'm throwing it out there. If we have time, if people are interested, we can talk about it more. And finally, especially since the language of coercive control has found its way into the Divorce Act, there's been a lot of talk about making it a criminal offense. That also has lots of pros and lots of cons. So those are the dessert topics if we have time to get to them. Let me wrap up by saying this, and then we'll open it up to all of you. I've been doing this work for a long time. I don't intend to stop anytime soon. It's hard work a lot of the time, but it's also incredibly rewarding work. Sometimes it's bleak. Sometimes it takes a very long time to see even a small change, and that can be discouraging. But I've also been inspired by women who, despite enormous challenges, show great courage in their efforts to keep themselves and their children safe. I've seen the positive impact of dedicated frontline workers who just don't take no for an answer when they're advocating for a client. I've met decision makers, lawyers, and judges who understand the need for change and who work so very, very hard to make it happen, often taking professional risks to do so. And so at the end of the day, first, I feel really honored to have been able to do this work. But I also do feel hopeful that as long as we all continue to bring our dedication, our passion, our commitment, and our brains together, positive changes will continue to happen. We can make family laws and courts and other intersecting systems into places that provide women and children who are fleeing abuse at what may be the most vulnerable and dangerous time in their lives, with outcomes that keep them safe. But more than that, with outcomes that let them move on to lives that are truly free from violence. Thank you for listening. Let's talk. Over to you.
Thank you so much, Pam. Maybe just one more round of applause. Thanks for doing that. We do have some time for questions. So in the room, just raise your hand and we'll acknowledge you, and I will track folks online. So if you are joining us through Zoom, please just type your question into the chat and we will acknowledge it.
Can I ask a question?
No. But since you loaned me your car while I'm here, yes.
I'm just going to be brave because it might seem like stupid or overly simple.
No.
So, with respect to the changes to the Divorce Act at the federal level, what impetus do specific jurisdictions have to harmonize their own legislation with that federal Divorce Act?
Well, there's no legal or political incentive. The family law has always been a split jurisdictional matter, which has led to, fair to say, a little bit of confusion at times, a lack of harmonization. I think the fact that the federal government, if we can believe Justin Trudeau, and who knows, after his performance of Bohemian Rhapsody there last week, he may be off to a career on the stage, but he claims that, I think it's today, he was going to sign the National Action Plan. which includes a huge dump of money to the provinces and territories to implement specific aspects of that plan. And it's money the provinces and territories are not allowed to use to clear deficits or to fund existing programs. So I think there's a message right now that we all have to work together generally on issues related to gender-based violence. And I think moving the family law ahead in provinces and territories that haven't done that yet is an obvious starting. But I'd like to know what lawyers here think. I don't practice here. Do you feel constrained by the Children's Act as it is now? Would you like to see the language that's in the Divorce Act?
Yes, I mean, absolutely.
Excellent.
And we're a small enough jurisdiction where you can effect change by having a conversation with the Minister of Justice, who is a friend of yours, or who
No,
well
it's a friend of Ron's.
What's his name? Well, yeah. Tracy and I go way back too, but you can, and we also have, Ron mentioned it in his opening remarks, we have a bench of 3 women who are all outstanding jurists in their own right, and who are all, I think, interested and engaged in adopting the change. When the Divorce Act amendments were made, the current presiding Chief Justice was very quick to talk to the family law bar about how do we get these changes to be reflected in law. So we can work on that. We can also effect those changes in practice by making submissions. My colleague, Mr. DeLibero, is here, and in making those submissions. And I've had cases of unmarried couples who I've been very clear about. There's absolutely no reason why we shouldn't be applying this standard, which has been nationally adopted in our current cases. So we can do it practically, we can do it politically, and I'm optimistic that we can try to get those changes, because they were a long time coming. And the changes to the Divorce Act in terms of changes in custody and access to parenting responsibility were many years coming, and some intervening minority governments federally, which caused them not to be able to be processed as quickly. But I'm optimistic that we can do that. And you also have the nice, I mean, it's a bad thing that there's so few family law lawyers in my course, but it's a good thing in the sense that we can all talk with one another and we can all sort of advocate some of these things unanimously. So I'm optimistic.
Thanks. Anybody else with a thought on Asia's question?
Yeah, I can just to carry that a little further. As a family lawyer here, when we knew the Divorce Act changes were coming, it was a while before they came into force, but we had the heads up. And for cases involving people who were not married, we're often incorporating things by reference. And the social science research and the research that's out there, there's a lot of helpful guides too to discuss courts of controlling violence. So we were bringing in things from outside and just saying, look, this is judicial notice, or however else we get it before the court. It's obviously relevant whether or not these 2 people got up on an altar or whatever they did to get married, the same relationships in place. So we were immediately referencing different definitions of family violence, but it's not consistent. I think that's your point.
That's my point.
That could be individual practitioners, but if you don't have the regulatory regime there, then it's hit or miss, and especially for self-represented people. I did have a question, but I can save it for later about screening. So I'm not sure if it's an appropriate time to ask about that.
I'm just going to check. I thought I saw a hand go up way in the back a little while ago. And do you want to go ahead?
One is an observation, and the other one is just.
Can you talk a bit louder? Sorry, I'm way down here.
I have 2 points to make. One is an observation, and just reflect what you're saying about women without justice, because the judges begin. But what you say is quite important. They acknowledge the abuse, and yet they say it's irrelevant in determining the custody of the child. I'm with you there, because advanced childhood experience, any childhood witnesses, as well as the elderly directly have an impact on them. I think where I come from in my country, immediately a man is violent, that shared custody for everything is irrelevant. So although I'm from Africa, which is the Western Argentina, our laws are updated, but when it comes to children, I'm 10 steps ahead. So my second point, I'm a social worker here, and there's an ethical dilemma, because the welfare of the child is paramount. So for us, it's the balance of probability when it comes to abuse. So this offensive, charming man who is an abuser, yeah, and they will show their abilities and qualities to be a good parent in the eyes of a social worker like me. I'll be like, yes, share custody. So I think my question is to the lawyers to represent the women who are suffering. Because deep down, I know it's wrong. But for us, it's about what is abuse. We have to obey the United Convention rights of the child. So the best interest checklist is an issue as a social worker. Because in one element is, okay, you know this is wrong, but it's all about what's written on paper. But I'm not allowed to go to the family court and say, oh, you shouldn't have access to children.
Those are both really important points. That I take the second one in particular, just because it's what you're dealing with here.
Yeah.
These aren't easy cases, and maybe this will lead us back to the question about screening. You know, they're not easy cases to figure out. And somebody who is abusive to their spouse can offer many positive things to their child, right? And as I said earlier, I've never suggested that there should be no contact between an abusive spouse and their children. But it has to be done in a way that takes into account, obviously, safety, but then that emotional well-being too. If I'm used to cowering in my bedroom while I'm hearing my dad, verbally abuse my mom, and now I'm expected to go off to dad's house for the weekend and I'm 6 or 7 years old, that's really scary for me. So how can we build that relationship back between the child and the parent so that the kid feels safe and comforted, but not like they're being told they can't see their father? Children love both their parents and they want to be loyal to both parents. It's a very difficult situation.
Lyndon Nielsen, whose work you will no doubt be familiar with,
yeah,
has a great online resource for lawyers and other people. It's been helpful, but part of this approach as a wiki book and in a way format, it's great because it can be updated, but I found in the screening section and the help toolkit as well, gets you to a point as a practitioner, but then there's these references to screening tools that seem to be a lot more formal, that require training either in psychology or social work, that I imagine something, because you can't actually get access to the tools themselves. They're behind a paywall, or they're behind, you need to be a trained psychiatrist or psychologist to deal with these things. I would love to have something that was a little bit more formal to run through with clients, or to give to clients to run through on their own time. And I've tried to get to the point where I can find out what those tools are, but it seems to be behind. Again, it may be because I may not, as a practitioner, be trained to administer the tool. But your help toolkit, just to close that question, gets to the point of, discuss this with your client, talk around the issue. We're often, unfortunately, dealing with a fairly limited time per client. And so it would be really helpful to have something more formal.
So I have a couple of comments back. Mm-hmm. And of course, I don't know what you've read, but
right.
Often there's a blurry line between risk assessment and screening. Mm-hmm. And when you do risk assessment, you do need specialized training, and we have no business doing it. Right. Us family law lawyers, So I don't know if some of what you're being referred to is actually a risk assessment tool. The screening, the federal government, and I think you had some involvement with DOJ when they were working on some of the Post-Divorce Act stuff. They're very reticent to call it a screening tool. And it's so interesting. Government is so interesting. 3 years before the changes to the Divorce Act, DOJ, Justice Canada, hired Lou's Place to do research into screening tools. That was the 2 words, screening tools, which we did. And that report, which you can get on their website, it's called What You Don't Know Can Hurt You. Yeah, that has a kind of template. But then by the time they took that research and turned it into the toolkit, they said, oh, we don't use the term screening tool anymore. So I get your confusion about the help resource, because they kind of walk right up to the door and then they don't walk through it.
While you talk about risk assessment, I'm sorry, I don't mean to monopolize this, but risk assessment is something that I'm not sure who does it in town, and maybe that's a local problem that I need to ask more about.
Police should be doing it, or should be trained to do it. Do you know if any of the shelters do it?
No.
I don't think that, no, definitely none of the shelters do it. And I don't think that RCMP within their response protocol necessarily, I think they often call up government.
The Jacqueline Campbell risk assessment tool is a really good one. It's not behind a paywall.
Mm-hmm.
It's not perfect because it's really focused on lethality as opposed to just ongoing abuse. But it's one that the client completes part of, and then whoever's doing it completes part of it. It's pretty accessible.
Yeah, it's just in the absence of that environment where you go, I know I'm not trained to administer a tool, but if I can do something, it may be better. Part of a practitioner, from a practitioner's standpoint, as you know, might be the decision to advise a client to go to court to get a restraining order.
Yeah.
And you may not want to do that if things are calming down or there wasn't a lot of recent violence. So I'm also trying to figure out, is this something I advise my client to go to court, which might make it blow up, right?
And whatever you do, you second think it, and whatever you do, sometimes you'll get it wrong. Maybe one final comment on risk assessment, and I don't really know who I'm saying this to, so I'll look vaguely around. There's some great risk assessment tools. Be Safer is one, and that's something you, as a community, could decide you wanted to work together and train some folks here to do it. It costs money. You bring in the trainer. It's a good tool. And you can find out a lot of information about it online, and maybe it's something that could be done jointly between some lawyers, some frontline agencies, the court. I don't know, but it might be a place to start. Yeah.
I just wanted to kind of speak to the risk assessment that you were just talking about. I do work at the women's transition home. So a lot of times what we do, and it's often overlooked with lawyers, is the women know their risk, right? So oftentimes it can be like women-led, like even though they're scared, even though they're in crisis, and they know their life and they're the experts on it. So when you suggest a restraining order, if she's like, it's a good indication to follow.
Yeah.
I've been in the family court system myself. I was stuck in it for 10 years, and I was lost to go do this. And I'm like, no, I can't do that. And then she'd call me about an hour later and be like, oh no, I talked to a different lawyer. They said no. Yeah, so it's often just follow her lead.
And just to respond to that, I think I do, and the challenge is more when the woman is reluctant or doesn't want to, but they're concerned about what might happen in court. And then they're trying to maybe in this phase where they're thinking about making it calm again. And that's what I find it really challenging, because if someone comes in and asks for a restraining order, it's like, all right, do we have, what we need? And but it's those situations where you're not sure that are really challenging.
I think something else that's challenging for family law lawyers is that a lot of women, and you'll see this at the transition house too, is they leave multiple times before they're ready to stay out. So, you spend an hour and a half or 2 hours doing an intake interview, you hear some really awful stuff that goes into your soul as well as your brain, and you make another appointment and she doesn't come back. And then it's easy to think, well, that was a waste of my time. I'm here to tell you it's not a waste of your time, because she's taking that away, just like she's taking away whatever she's learned at the transition house. And the next time she's closer to being ready, and she comes back a year and a half later or a year later, she hasn't forgotten what you said to her. But I couldn't agree with you more. She's managing her safety in the best way she can, given the situation she's in at the moment. So if she's planning to go back home at the end of her appointment with you, she doesn't want some letter from you showing up at her house, or a phone message left on her phone, or an application for a restraining order. She's going back to think, I'm not really going back to reconcile. I'm going back because I don't have enough money to get out yet. Or I want to wait till the school year is over. Or he's going hunting in 3 months, and then I've got this chunk of time when I can get out without him coming home at the end of the day, right? So that's why it's so hard to do this work as a lawyer, because we see this one little moment, but all this other stuff is going on.
Pam, you had mentioned that in the new Divorce Act, they have included definitions that relate to or refer to coercive control. My understanding is that coercive control is not included or defined in Canada's criminal code.
It doesn't exist in the criminal code.
Do you anticipate or do you think that should amendments to Canada's criminal code include coercive control as a definition, that might undermine the strength of those changes to the Divorce Act where coercive control?
No, I don't think it'll undermine the changes to the Divorce Act. Maybe if I've only learned one thing since 1998, it's that every change for the better has unanticipated negative consequences. And so even though when I started out doing this kind of advocacy, I'd meet with a politician, I'd be like, can we do that tomorrow? Can we do that tomorrow? No. And now I'm the one saying to government folks, let's slow this down a bit. So when I think about criminalizing coercive control, I have very, very mixed feelings about it. A lot of transition house workers across the country strongly want to see it criminalized. And I understand why. But when I was in practice and clients would come into my office and describe the most awful emotional abuse, we weren't using the language of coercive control then. And they'd say, so, but I called the police and they said there's nothing they can do. And I would have to say, you're right, there is nothing they can do, which seemed wrong, right, to me. But I've seen too many other changes that were supposed to help women turn around and not work for them. So if we criminalize coercive control, who's going to get charged? That persuasive abuser who's able to say to the police, it was just an argument. We were joking. And she isn't able to articulate the level of fear or the level of lost autonomy that she has. Are people of color, Indigenous people, poor people going to be charged more than somebody like me, nice white lady in a house in a middle-class part of my city? I'm very articulate. I'm a lawyer. I can talk my way out of anything, right? So I think it's worthy of serious consideration. There is a good paper that, well, there's two good papers. One was written by the Federal Standing Committee on Justice and Human Rights, and it's a weird way to find it. I think you probably can find it if you just do Google that. It's good. It's a good paper, and it suggests questions that we should think about. But Liz Place published a paper last year as well that you can find on our website that looks at the possible challenges in criminalization and looks at the experiences in countries that have criminalized it, which haven't been that exciting. So some food for thought there.
And on that note, I think Pam has been extremely gracious with her time, or maybe Ron has been gracious with her time. So I'm going to call the proceedings to a close. And once again, please join me in thanking Pam Cross.